Hello friends, welcome back to series of lecture. This is the 11th lecture of this series of Indian Evidence Act, and we are continuing with section 92. In the previous lecture we had seen up to proviso 4. Let's continue with the proviso 5 of this section. Section 92. Any usage or custom by which incidents not expressly mentioned in any contract are usually annexed to contracts of that description may be proved, provided that annexing of such incident would not be repugnant to or inconsistent with the express terms of the contract. So they are saying any usage or custom. So बहुत सारे बिजनेस ट्रांजेक्शन्स हैं जिनमें कुछ प्रैक्टिसेस प्रिवेल करती हैं. आप डॉक्यूमेंटेशन करोगे फिर भी there are certain practices which prevail in some kind of business transactions and which is conventionally going on from several decades. So in those cases, even if the contract is documented, that usage or custom will prevail that go along with the contract, that will also be considered to be a part of the agreement. So इस तरीके के बहुत सारे बिजनेस ट्रांजेक्शन्स हैं जिसमें यूसेजेस और कस्टम चलते हैं. अब जैसे कोई बिजनेस ट्रांजेक्शन्स हैं, कॉन्ट्रैक्टर्स होते हैं, हाउसेज के कॉन्ट्रैक्टर जो घर वगैरह डेकोरेट करने या फिर बनाने के लिए कॉन्ट्रैक्ट करने के लिए छोटे छोटे कॉन्ट्रैक्टर्स रहते हैं. वो कॉन्ट्रैक्ट लेते हैं किसी घर का कि 1 मंजिल मकान बनाना है, 1 फ्लोर पूरा. तो वो मार्केट से आइटम्स उठाते हैं, ब्रिक्स है, सीमेंट है, एंड इलेक्ट्रिकल आइटम्स, प्लम्बिंग आइटम्स, सो मैनी आइटम्स. तो उसमें वो जो पेमेंट है वो मार्केट में सेलर होते हैं उनको एक साथ नहीं वो साथ के साथ नहीं करते, हैंड इन हैंड. उनकी कुछ क्रेडिट रहती है, क्रेडिट वैल्यू. तो वो जब ओनर होता है जो हाउस का जिसका कॉन्ट्रैक्ट लिया है उससे जब पेमेंट प्राप्त कर लेते हैं पूरा, उसके बाद वो उसके कुछ टाइम बाद वो उनको पेमेंट करते हैं शॉपकीपर्स को. सो दे गॉट द क्रेडिट ऑफ दैट नंबर ऑफ डेज फ्रॉम द मार्केट. So in that example, if that is the person where a person get into the written contract with the seller, and in that agreement if there is no term regarding as to how the payment is to be given, so the document is silent regarding the payment and there is no oral agreement for that. अगर oral agreement होता तो आपका proviso number 2 लग जाएगा. Proviso number 2 क्या कहता है? If it is an informal document and it is silent upon something, and if it is an oral agreement, then it would be allowed to prove. But in the present example I am giving, they have entered into a transaction and there is no agreement regarding the date of payment, time of payment. But as a matter of conventional practice, the 30 days was given, suppose. So conventional practice के हिसाब से 30 days credit दी जाती है. So that 30 days credit will be a part of contract. So you can always give evidences to prove such custom, usage or convention. If there is a dispute and suppose the opposite party wants the payment immediately and you say no, as per the convention practice 30 days credit have to be given. So you can give evidences, oral evidences also, to prove that fact of convention, usage or custom. Usage, custom or convention में there are so many such practices. Any usage or customs, read it again. Any usage or custom by which incidents not expressly mentioned in any contract are usually annexed to contracts of that description. So automatically that custom will apply upon that contract because that custom exists in that transactions, because that custom exists in that transaction of that description may be proved. Now proviso, provided that the annexing of such incident would not be repugnant to. What is meant by repugnant? Repugnant means inconsistent. It means opposite. Repugnant to something means opposite to something. Both both of them cannot exist together. Repugnant to or inconsistent with. Inconsistent थोड़ा लाइट होगा. Inconsistent भी अपोजिट टाइप हो गया, बट टोटली अपोजिट ना भी हो, थोड़ा लाइट तरीके का अपोजिट होगा. तो ना भी हो अपोजिट, बट दे कैन नॉट स्टैंड टुगेदर. इट मीन्स दे कैन नॉट स्टैंड टुगेदर. एंड repugnant is totally opposite. Repugnant to or inconsistent with the express terms of the contract. Express terms of the contract. So जो यूसेज कस्टम और जिसको कॉन्ट्रैक्ट में एक्सप्रेसली मेंशन नहीं कर रखा, उसका प्रूफ दिया जा सकता है, बट सच इंसिडेंट वुड नॉट बी रिपग्नेंट. अपोजिट नहीं होना चाहिए विद द एक्सप्रेस टर्म्स ऑफ द कॉन्ट्रैक्ट, या फिर इनकंसिस्टेंट भी नहीं होना चाहिए. नाउ लेट्स सी द अनदर प्रोवाइजो, लास्ट प्रोवाइजो 6. बट बिफोर दैट just make a quick revision what we have seen. So one, we have seen the things related to the illegality of the transaction. Then the other thing we have seen is the document is silent and the document should not be very formal. Then the third is the condition precedent. Document is silent upon the condition precedent and there is a oral agreement upon condition precedent. Then the fourth one is distinct and subsequent oral agreement to alter the very express terms of the contract or to rescind the very express terms of the contract. Then fifth one is usage. Any custom or usage, and if it is no agreement regarding that, no oral agreement, no written term, and if it is not inconsistent with the transaction contract, then that custom or usage can be proved. अब ये भी देखो फिल इन द ब्लैंक्स की तरह है आपका. अगर आपने एग्रीमेंट किया और किसी पॉइंट पर साइलेंट हो और यूसेज और कस्टमरी प्रैक्टिस पहले से उस पर चल रहा हो, वहाँ पर दिस इज कम्प्लीमेंट्री. सिमिलरली फॉर दिस ऑल्सो, आपने एग्रीमेंट किया बट यू आर साइलेंट अपॉन समथिंग एंड देयर इज एन ओरल एग्रीमेंट रिगार्डिंग दैट पॉइंट, सो दैट इज ऑल्सो कम्प्लीमेंट्री. कंडीशन प्रेसिडेंट के लिए भी देयर इज नो डिस्टिंक्ट mention into the document, but the condition precedent is agreed between the parties. So there is also, it is complementary. Legality is a totally different thing. There is direct question upon the legality of the document, whole of the document. But in the fourth clause, so fourth point and the main and different point is, if a document is brought into something written and your agreement is opposite to that document or opposite to term, then there clause 4 is applied. And there, if you prove that this is distinct and subsequent, then oral evidence will be allowed. Now the last one is also slightly different. Read it once. Any fact may be proved. Any fact may be proved which shows in what manner the language of a document is related to existing facts. Any fact may be proved which shows in what manner the language of a document is related to existing facts. This will apply only when the document का language is ambiguous, vague. Now suppose there is a document between A and B, and in that there are some terms are written, all the terms are written, and out of those terms some terms are not clear. There is some ambiguity in those terms. Ambiguity means uncertainty, or the document is vague. Maybe not the entire document, but some terms are vague. Either the entire document or part of the document is ambiguous, or it is vague. Then in that case, the oral evidence can be given of the surrounding circumstances to infer the intention of the parties. Actually इस document में पार्टीज का इंटेंशन क्लियर नहीं हो रहा एक्चुअली व्हाट दे हैड टू डू, व्हाट दे एक्चुअली इंटेंडेड टू डू, दैट इज नॉट क्लियर, और अपॉन सम टर्म from the document the intention is not clear. So you have to understand some real intention of the parties. So obviously you cannot throw away the document. You will give the evidences of the surrounding circumstances at the time when the transaction enter into, उन परिस्थितियों में जिन परिस्थितियों में वो ट्रांजैक्शन हुआ था, जो आसपास की परिस्थितियां थीं, पार्टीज का म्यूचुअल कंडक्ट था, वो सारी बातें आप प्रूव करोगे पार्टीज के इंटेंशन को प्रूफ करने के लिए. सो दैट इज व्हाट प्रोविजो 6 टॉक्स अबाउट. किन परिस्थितियों में तुमने ट्रांजैक्शन किया, उन परिस्थितियों में पार्टी का क्या इंटेंशन रहा होगा, दैट इज व्हाट हैज टू बी एग्जामिन्ड. इन व्हाट सर्कमस्टेंसेस यू विल गेट इनटू द ट्रांजैक्शन, एंड इन दोज सर्कमस्टेंसेस व्हाट वुड बी हैव बी द इंटेंशन ऑफ द पार्टी, एंड द इंटेंशन इज ऑफ दैट टाइम, not of today, when the it is of when the contract was made. Contract was entered into just before the transaction, just before the contract. What was the conduct of the parties, what was the intention of the parties? After the contract, what was the conduct of the parties? All those things to be seen, not only the conduct but other circumstances also to be seen. जैसे what was the proprietary pecuniary state of A, what was the proprietary and peculiar state of A, and what was the proprietary and peculiar state of B. उसने ये ट्रांजैक्शन कॉन्ट्रैक्ट क्यों किया था, उन सब चीज को देखकर then you will infer the real intention of the parties. But this proviso 6 will apply only when the document is vague. अब मान लो डॉक्यूमेंट में कोई एम्बिग्यूटी नहीं है. If the document is not ambiguous, the document is very crystal clear about the facts, but one of the parties wants to give the different meaning to the document by proving the evidences of the surrounding facts. Means the intention when the document is signed is very clear, but one party, to take the benefit, to take the advantage, he want to give the different meaning and different intention to the document by proving some evidences of the surrounding circumstances. Are you allow that? अगर डॉक्यूमेंट में कोई एम्बिग्यूटी नहीं है, then in that case no evidence will be allowed to give a different meaning to the document. और इस पे प्रोवाइजो 6 पर एक केस लिख लीजिए. गोधरा इलेक्ट्रिसिटी कंपनी वर्सेस स्टेट ऑफ गुजरात 1975 सुप्रीम कोर्ट. And another case is SBI, State Bank of India, and another versus Mullah Sehkari Sakkar Karkhana Limited 2006 Supreme Court. So write down, Proviso 6 will apply only when there is an ambiguity about the document or some terms of the document. The evidence of the surrounding circumstances at the time when the contract was entered into, including the conduct of the parties at the time of entering into the contract, or their conduct before or after the contract, can be proved. The purpose is to know the real intention between the parties. The purpose is to know the real intention of the parties, of the parties. However, Proviso 6 will not apply in those cases wherein the document is not at all ambiguous. A party cannot be allowed to prove evidences to impute a different intention than what the party initially had. Means आपका डॉक्यूमेंट अगर क्रिस्टल क्लियर है तो बाद में अगर आप अपने फ़ायदे के लिए टर्न अराउंड करना चाहें और बोलें कि नहीं मेरा मतलब ये नहीं था, आई हैव डिफरेंटली मीनिंग समथिंग एल्स, और जहाँ पर डॉक्यूमेंट कहता है कि आपका क्लियर इंटेंशन ये था, तो डॉक्यूमेंट जब बोल रहा है कि आपका ये इंटेंशन था तो उसी इंटेंशन पर आपका कॉन्ट्रैक्ट परफॉर्म होगा, क्योंकि आपके कॉन्ट्रैक्ट का जो इंटेंशन शुरू में था दैट इज व्हाट हैज टू बी परफॉर्म्ड। तो बाद में अगर आप अपने फायदे के लिए इंटेंशन मोल्ड करना चाह रहे हो देन दैट विल नॉट बी अलाउड। हाँ, अगर इंटेंशन क्लियर नहीं है डॉक्यूमेंट से तब आप उसके ऊपर एविडेंसेस दे सकते हो टू प्रूव द रियल इंटेंशन ऑफ द पार्टीज। अब क्लास 4 में एक बार पॉइंट बताता हूँ मैं आपको। एनी डिस्टिंक्ट सब्सिक्वेंट ओरल एग्रीमेंट टू रिसाइंट और मॉडिफाई। मॉडिफाई में तो कोई ना कोई टर्म आ जाएगा, टू टर्म कोई मॉडिफाई किया है तो, या फिर रिसाइंड किया है। और रिसाइंड एनी सच कॉन्ट्रैक्ट और मॉडिफाई एनी सच कॉन्ट्रैक्ट, अगर कोई मॉडिफिकेशन है किसी टर्म में या फिर रिसाइंड पूरा का पूरा कॉन्ट्रैक्ट कर दिया, ग्रांट डिस्पोजिशन और प्रॉपर्टी में भी प्रूव, तो उसको प्रूव किया जा सकता है। सो इसमें जो एविडेंस देंगे कि दैट द पर्टिकुलर टर्म इज, अगर एक पर्टिकुलर टर्म रिसाइंड किया है, दैट पर्टिकुलर टर्म इज रिसाइंडेड एंड देयरफॉर द कॉन्ट्रैक्ट टू बी परफॉर्म्ड ऑन न्यू टर्म्स। इसके लिए ओरल एग्रीमेंट दे सकते हैं हम, ओरल एविडेंस। अब मान लीजिए पूरा का पूरा कॉन्ट्रैक्ट रिसाइंड हो गया, पूरा का पूरा कॉन्ट्रैक्ट ही रिसाइंड हो गया, तो फिर तो वहाँ पे पूरे रिसाइंड के लिए ही प्रूफ देंगे हम। तो वहाँ पे हम ये नहीं बोलेंगे कि दैट ऑन न्यू टर्म्स द कॉन्ट्रैक्ट टू बी परफॉर्म। तो वहाँ पे तो सीधा सीधा बोलेंगे दैट आई एम गिविंग ओरल एविडेंस फॉर द रिसाइंड ऑफ द होल कॉन्ट्रैक्ट, क्योंकि यहाँ पे तो पूरा कॉन्ट्रैक्ट रिसाइंड हो गया। तो फिर उसके लिए एविडेंस देंगे कि दैट द कॉन्ट्रैक्ट इज नॉट नीडेड टू बी परफॉर्म बिकॉज होल कॉन्ट्रैक्ट इज रिसाइंड। जो अर्लियर हमने एग्जाम्पल देखे थे वी आर टॉक अबाउट इन दैट इज सम टर्म्स ऑफ द कॉन्ट्रैक्ट, रिसाइंड ऑफ द सम टर्म्स ऑफ कॉन्ट्रैक्ट। उसमें कॉन्ट्रैक्ट एग्जिस्ट कर रहा है और उसका कोई टर्म रिसाइंड हो गया या मॉडिफाई हो गया, तो उसके टर्म के रिसाइंड का या मॉडिफिकेशन का आप एविडेंस दे सकते हो। अगर पूरा का पूरा कॉन्ट्रैक्ट रिसाइंड कर दिया है जो कि लिखा है इसमें कर सकते हो आप, तो उस पर भी एविडेंस दोगे आप फॉर रिसाइंडिंग ऑफ कॉन्ट्रैक्ट, बट द रिजल्ट इज दैट द कॉन्ट्रैक्ट इज नॉट एनफोर्सेबल। अब एक प्रोबेट के बारे में बताया था, प्रोबेट ऑफ विल, प्रोबेट कोर्ट। तो उसमें जेन्युइननेस ऑफ विल कैसे कोर्ट डिसाइड करेगी, तो मैंने बताया था आपको दैट न्यूज़पेपर में निकलेगा, सर्कुलेट होगा, बताया जाएगा कि किसी को कोई ऑब्जेक्शन है कि नहीं। तो उसमें अगर कोई आता है ऑब्जेक्ट करता है कि दैट इस व्यक्ति के बता रहे हैं कि विल बनाई है उसने, उसको तो पढ़ना लिखना ही नहीं आता था, इस तरीके के अगर कोई ऑब्जेक्शन है किसी के पास तो उसको उठा सकता है उस कोर्ट में। बाय दैट द कोर्ट विल गो ऑन टू प्रूव and decide whether the will is genuine or not by the objections only. Now let's see the illustrations. A policy of insurance is affected on goods in ships from Calcutta to London. That is a policy of insurance in which the goods are insured through ships. Goods are insured in ships when the goods are going from Calcutta to London. Then इंश्योरेंस करवाते हैं जब वो जाते हैं एक प्लेस से दूसरे जगह पे गए लोग। Then the goods are shipped in a particular ship which is lost. So the ship is lost. The fact that particular ship was orally accepted from the policy cannot be proved. Why? So the answer is, first of all, it was a document and therefore the 92 says that the document is conclusive. Now what you are saying is the document इंश्योरेंस कॉन्ट्रैक्ट, इंश्योरेंस कंपनी कहता है कि जो हमने इंश्योरेंस कॉन्ट्रैक्ट किया था उस नाम के शिप को हमने ओरली कह दिया था कि इस शिप का हम इंश्योरेंस नहीं करेंगे। अब इसमें जब कंपनी ने इतना फॉर्मल डॉक्यूमेंट बनाया है, बिकॉज इंश्योरेंस डॉक्यूमेंट्स आर वेरी फॉर्मल, बता चुका हूँ, एंड इन दैट इफ यू वांट टू स्किप समथिंग, बी एन एक्सेप्शन और समथिंग, then that should have been mentioned in the document. So the proviso number 2 here will not apply. Reason being, proviso number 2 is talking about the informal document and the insurance document is an extremely formal document. Insurance document बहुत extremely formal document है, and therefore Any kind of exemptions, exceptions, etc. should have been written in the document. Even if you are having the oral agreement to accept that particular SIP, that would not allowed to give evidence for proving it. Reason being that it is extremely formal document. Illustration B. A agrees absolutely in writing to pay B rupees 1000 on 1st March 1873. The fact that at the same time an oral agreement was made that the money should not be paid till the 31st March cannot be proved. Why? अब आप इसको इस तरीके से एग्जामिन करो, क्या ये प्रोवाइजो 1 से रिलेटेड इलीगैलिटी से मतलब है? इसका कोई नहीं है। प्रोवाइजो 2 है नहीं, साइलेंट है नहीं ये। देन कंडीशन प्रेसिडेंट है नहीं ये। कंडीशन प्रेसिडेंट तो वो होता है ऐसा करोगे तब कॉन्ट्रैक्ट परफॉर्म होगा। यहाँ पे तो डेट ऑल्टरेशन की बात हो रही है। और कस्टम यूसेज का कुछ है नहीं इसमें, एम्बिग्यूटी है नहीं, डेट इज क्लियरली रिटन। देन ओनली एग्जामिनेशन इज द प्रोवाइजो 4, और प्रोवाइजो 4 भी लगाओ, इट विल बी एप्लीकेबल ओनली इफ द कॉन्ट्रैक्ट इज डिस्टिंक्ट एंड सब्सिक्वेंट। अब यहाँ पर दे आर सेइंग एट द सेम टाइम। A agrees to absolutely in writing to pay so and so time at the same time means contemporaneous। अगर आपने contemporaneous agreement किया है to alter the term, क्योंकि टर्म तो क्लियर लिखा है कि 1 मार्च 1873 को पे करोगे, तो उसको आपने ऑल्टर करके 31 मार्च कर दिया है। सो ऑल्टरेशन ऑफ द टर्म अगर आप करते हो तो एग्रीमेंट शुड बी डिस्टिंक्ट एंड सब्सिक्वेंट, but here it is contemporaneous and therefore proviso 4 will not apply. So in this kind of questions always examine each of these proviso, that which will be applicable. तो प्रेमा फेसाई तो आपको सारे दिख जाएंगे, तो उनमें से एक दो आपको डीपली एग्जामिन करना पड़ेगा। सी illustration. An estate called the Rampur Tea Estate is sold by a deed which contains a map of the property sold. The fact that land not included in the map had always been regarded as part of the estate and was meant to pass by the deed cannot be proved. So in this, the deed is containing the details of the property through the map, and in this what they are trying to prove that मैप जो लगा है इसके साथ, जब डीड के साथ लगा हुआ है, उसमें पर्टिकुलर मैप भी दे रखा है कि किस प्रॉपर्टी को हम सेल कर रहे हैं। वो प्रूव करना चाह रहे हैं कि जो मैप में नहीं थी, जो पीस ऑफ लैंड, दैट ऑलवेज बी द पार्ट ऑफ दैट रामपुर टी स्टेट। इस फैक्ट का प्रूफ नहीं दे सकते। सपोज दिस इज द मैप which is attached in the sale deed Rampur Tea Estate. Suppose this is the property which is also the part of the Rampur Tea Estate, but in the deed this property is not shown. Indeed, only this much property is shown. ये वाला पोर्शन उन्होंने ड्रॉ नहीं किया है। Now the purchaser is claiming the rest part of property, this part also, for sale. Now the seller says it was not sold because the map does not include this property, this part. Now can the purchaser give the oral evidence to prove that this portion of land is also the part of that estate? So for this you have to examine the provisos. If you will read the first read it again. An estate called the Rampur Tea Estate is sold by a deed which contains a map of the property sold. The fact that land not included in the map had always been regarded as part of the estate and was meant to pass by the deed cannot be proved. The first proviso is illegality, that is not concerned in this case. Then the document is silent. इसके बारे में आप you can think of it. Then condition precedent is not here. Distinct and oral agreement, it is also not the case. Then ambiguity, there is no ambiguity in the document because it clearly says that this is the property and the portion of land is excluded from the map. So there is no ambiguity. इसको भी आप नहीं ला सकते. अब कस्टम एंड यूसेजेस, कस्टम भी यहाँ लगेगा नहीं क्योंकि कस्टम शुड बी ए जनरल कस्टम फॉर ए commercial transaction. So it is not a general custom. It has been considered to be a part of that property, that tea estate, but that is not a general custom. That is only with respect to that particular property. Because proviso 5 mein they are saying any usage or custom by which incident not expressly mentioned in any contract are usually annexed to the contract. Usually annexed to the contract. So this is not about the general transaction. This is only about the one transaction of the T state. So the proviso 5 will not apply here. Now as far as this proviso is concerned, 2. Now it is silent, it is sale deed. Maybe you say that it is not a very formal document. But if the sale deed is silent upon something and this property is not included in that, then can you say that this property was intended to included? Had it be intended to included, then that should have been mentioned. Now in proviso 2 they are saying the existence of any separate oral agreement as to any matter on which a document is silent. But in this case there is no separate oral agreement regarding that properties. You are simply saying that that property should be considered to be a part, that portion to be considered to be a part. लेकिन आपने कोई आपस में oral agreement तो नहीं किया ना, and therefore the proviso 2 will also not apply, and hence they are saying that oral evidence cannot be given. Oral agreement cannot be given. So like this you have to examine each and every proviso for in exam for a question. So ये वाला example हमारा custom में भी नहीं लगेगा because for the custom there has to be a general custom, but in this case it is not a general custom. It is not general custom that all such property or land, it is only one property, and therefore that is not said to be a general custom. And as far as the remaining silent is concerned, no doubt the document is silent upon that portion, but the document is very explicit about the fact that this is the portion or the property that has been sold. और moreover आप silent वाले part पर oral evidence कब दे सकते हो? When there was distinct oral agreement. So there is no distinct oral agreement here, and therefore neither of this proviso will apply. Now the next one, A enters into a written contract with B. A enters into a written contract with B to work certain mines. The property of B upon certain terms. A was induced to do so by a misrepresentation of B's as to their value. This fact may be proved. So here it is misrepresentation. Proviso 1. Then illustration E. A institute a suit against B for the specific performance of a contract and also praise that the contract may be reformed. Reformed means changed as to one of its provisions, as that provision was inserted in it by mistake. A may prove that such a mistake was made as would by law entitle him to have the contract reformed. Contract reform. So this will fall in proviso 1, that is mistake. In proviso 1, such a mistake. F. A orders goods of B by a letter in which nothing is said as to the time of payment and accepts the goods on delivery. B sues A for the price. A may show that the goods were supplied on credit for a term still unexpired. So in this you can think of proviso 2 and 3, or you can think of proviso 5 also. अब whether this is apply or not you will have to examine. अब illegality तो है नहीं, तो first proviso will not apply. अब the document is silent about the time of the payment, so you can think about it. कंडीशन प्रेसिडेंट का कोई मतलब नहीं है, डिस्टिंक्ट एंड सब्सिक्वेंट ओरल एग्रीमेंट है नहीं. कस्टम पे यू कैन थिंक अबाउट, एम्बिग्यूटी इज नॉट देयर. अब एम्बिग्यूटी मीन्स टाइम ऑफ पेमेंट नहीं है, यू कैन ऑलवेज टॉक अबाउट द सर्कमस्टेंसेस. सर्कमस्टेंसेस से आप टाइम ऑफ पेमेंट प्रूव कर दो, सो एम्बिग्यूटी भी आप सोच सकते हो. मेनली यहाँ पर साइलेंट वाला पार्ट और कस्टम वाला पार्ट. So read it again. A orders goods of B by a letter in which nothing is said as to the time of payment and accepts the goods on delivery. So he has taken the goods on delivery. When the payment has to be made, the document is silent upon that. B sues A for the price. A may show that the goods were supplied on credit for a term still unexpired. So you see when you talk about silent, no, अब साइलेंट वाले केस में देयर हैज टू बी ओरल एग्रीमेंट. अब ऐसा कोई ओरल एग्रीमेंट यहाँ है नहीं, तो वो सेकंड वाला पार्ट तो लगेगा नहीं इसमें, सेकंड प्रोवाइजो. अब एम्बिग्यूटी की बात कर सकते हैं हम, क्योंकि डॉक्यूमेंट इज एम्बिगुअस अबाउट द टाइम ऑफ पेमेंट. फॉर दैट पर्पज द सराउंडिंग सर्कमस्टेंसेस का एविडेंस कैन बी गिवन बाय द पार्टी. But more importantly, the custom wala proviso will apply here, because in those kinds of transactions, if there is a custom prevailing which allows the payment, delivery which allows the delivery on credit, so that customs can be proved. But in this illustration they are not making very clear as to whether there is a custom or not. But in this case agar customs prove kar do, so that can be proved, or you can prove the surrounding circumstances to clear the ambiguity. So in this case, the proviso number 5 or proviso number 6 can be applied. Now G. A sells B a horse and verbally warrants him sound. A sells B a horse and verbally wants him sound. A gives B a paper in these words: bought of a horse for rupees 500. B may prove the verbal warranty. So in this, the paper is not mentioning about the soundness of mind of the horse, but that was a verbal guarantee that is given by A to B. अब प्रोवाइजो 1 में अगर आप फ्रॉड वगैरह प्रूव कर दो तो प्रोवाइजो 1 लग जाएगा. So if it is a case of misrepresentation or fraud, then the proviso 1 is applicable. Now as far as proviso 2 is concerned, the document is silent upon the horse's sound or not, but in that regard there is a oral statement. There was oral statement that the horse was sound, so it can be proved under proviso number 2 as well. So proviso number 2 क्या कहता है कि that document is silent. अब यहाँ पर document formal नहीं है, it is not a formal document. The document is silent upon one of the terms as to whether the horse is sound or not, and the party is agreed only when the horse is sound. Now as far as proviso 3, the existence of any separate oral agreement constituting a condition precedent to the attaching of any obligation under any such contract may be proved. So this can also be applied because the purchase was done on the condition. Usually any purchase is done of a horse that the horse is sound. अब उस condition precedent के लिए that separate statement be made by the party that the horse actually is sound. But proviso 3 आप डायरेक्टली नहीं लगा सकते हो, डायरेक्टली 2 लगेगा, क्योंकि कंडीशन प्रेसिडेंट में अगर इसमें डायरेक्टली ये कहा गया होता इस इलिस्ट्रेशन में कि आई वुड परचेज द हॉर्स इफ द या फिर इस तरीके से कहा गया होता कि इफ द हॉर्स इज साउंड आई विल परचेज इट। अब नेक्स्ट, प्रोवाइजो 4 का तो कोई मतलब नहीं बनता, कस्टम वगैरह का यहाँ कोई मतलब नहीं है, एम्बिग्युइटी का कोई मतलब नहीं है, तो बचा कौन, प्रोवाइजो नंबर 1 और 2। प्रोवाइजो नंबर 1 लग सकता है इफ इट इज मिसरिप्रेजेंटेशन और फ्रॉड, और 2 लग सकता है। अब इसमें फर्स्ट क्लियरली इसलिए नहीं बोला क्योंकि इफ पार्टी पर से alleged दैट इट इज ए फ्रॉड और मिसरिप्रेजेंटेशन तो फर्स्ट क्लियरली लग जाएगा। Now H. A hires lodging of B and gives B a card on which is written rooms rupees 200 per month. A may prove a verbal agreement that these terms were to include partial board. What is mean by board? Lodging means to stay and board means have food. Means food and stay, both of them, lodging and board. When there is only stay then it is lodging. जब boarding के साथ में है then it will include food also. अब यहाँ पर agreement says clearly that rooms 200 per month. So in this agreement is explicit about lodging 200 per month. But this agreement is not talking about boarding. A may prove a verbal agreement that these terms were to include partial board. अब इसमें क्या लगाओगे आप, पहले वाला आप लगेगा नहीं illegality वाला. In this the document is silent and you want to prove a oral agreement and that is not inconsistent with the lodging. Document आपका silent है, oral agreement आप prove करना चाह रहे हो, and regarding that boarding also, lodging आपका contract में है ही and it is not inconsistent with the lodging. Boarding is not inconsistent with lodging and therefore directly proviso number 2 will apply. अगर आप condition precedent के रूप में इसको प्रूव करना चाह रहे हो that there is condition precedent that boarding would be provided, then proviso number 3 can also be applied. proviso number 4 लगेगा नहीं. proviso number 5 आप लगा सकते हो अगर आप ये प्रूव कर दो कि in that kind of lodging the boarding always be provided. बट ऐसा कुछ लिखा नहीं है तो proviso 5 तब लगेगा when there is custom, तो ऐसा कोई स्टेटमेंट है नहीं यहाँ पे. Here there is no question of custom, here it is simple agreement. Here it is simple oral agreement that boarding will also be provided. हाँ, इधर ऐसा होता कि that other lodgings also their surroundings nearby providing from since long time that boarding also and this lodging also providing boarding from 5 years. उस तरीके में स्टेटमेंट में यहाँ पर लग जाता है. proviso 6 का कोई मतलब है नहीं, ambiguity as such is not there. So therefore proviso 3 may apply, proviso number 2 will apply, may apply. तो proviso 3 भी indirectly लगेगा, but as per wordings only the proviso number 2 will apply. अब next पैरा देखते हैं इसका. A hires lodging of B for a year and a regularly stamped agreement drawn up by an attorney is made between them. It is silent on the subject of board. A may not prove that board was included in term verbally. Why? Because it is an extremely formal document. So जो proviso number 2 का latter part है that will exclude the proof and therefore it is not allowed. Now next I. A applies to B for a debt due to A by sending a receipt for the money. A applies to B for a debt due to A by sending a receipt for money. B keeps the receipt and does not send the money. In a suit for the amount, A may prove this. I. A applies to B for a debt due to A by sending a receipt for the money. B keeps the receipt and does not send the money. in a suit for the amount, A may prove this. Now इसमें you will see all these proviso and you will find which will apply. Applyment. Illegality है नहीं इसमें. Silent second proviso लगेगा नहीं. Condition precedent इसमें है नहीं. Fourth लगेगा नहीं. Distant and subsequent हुआ नहीं है. Usage custom है नहीं. Ambiguity document में है नहीं. And there is no oral agreement later on. So in this illustration, none of these proviso will apply because receipt of money is not a term of contract. I have given a loan to you and you are supposed to give back loan to me. And now for your faith, what I have done is, without receiving the money, I signed the receipt and send it to you, that you keep the receipt and give the money. मैंने अपने किसी एजेंट के थ्रू रिसिप्ट साइन करके आपको दे दिया और कह दिया कि रिसिप्ट आप रख लो, पैसे मुझे भिजवा दो. You kept the receipt but you did not give the money. Now if tomorrow I file a suit against you and there you are claiming that, look, I have got the receipt and I had paid the money to him already. Now I have to prove that I have given the receipt but he has not given me the money. So this proof that I try to give that I have given the receipt but he has not given me the money. So that is not the term of a document that I want to prove. I am going to prove. I am trying to prove only a transaction that the money was not paid and I have given the receipt. And therefore that will be out of the ambit of 91 and 92. और जब 91 के बाहर होगा तो 92 लगेगा नहीं. So anything which has to fall into the proviso first fall in 92 and anything in order to fall into 92 first fall into 91, and if anything does not fall in 91 then neither 91 then nor 92, then it will not also fall into proviso. अब याद करो 91 में that if there is transaction in which you have paid the money, इसमें ये illustration है. A gives B receipt for money paid by B. Oral evidence is offered of the payment. The evidence is admissible. So this situation is somewhat like that. Now here oral evidence is admissible means it is out of 91. And when it is out of ambit of the 91, then 92 will not apply. So therefore the second last illustration is the case where 92 itself will not apply because section 91 is not applicable. Now write down on this illustration. In the case of illustration I of section 92, the fact that is sought to be proved is that there was a transaction in which the receipt of money was given by A to B, but B did not pay the money in lieu of receipt. Here the above transaction is only about the delivery of receipt without payment of money. Therefore, it cannot be said to be a term of contract. Hence, it will not fall under section 91, and something which does not fall in section 91 will never fall under section 92 or any of its provisos. Now see the illustration J. A and B make a contract in writing. A and B make a contract in writing to take effect upon the happening of a certain contingency. The writing is left with B, who sues A upon it. A may show the circumstances under which it was delivered. अब इसमें देखिए आप कौन सा प्रोवाइजो लगेगा. Now in this see which proviso will apply. अब इसमें देखिए आप किसी कॉन्ट्रैक्ट का टर्म प्रूव करना चाह रहे हो या कोई ट्रांजैक्शन प्रूव करना चाह रहे हो. अगर ट्रांजैक्शन प्रूव करना चाह रहे हो तो 91 लगेगा नहीं, 91 लगेगा नहीं तो 92 में जाओगे कैसे. Read it again. A and B make a contract in writing to take effect upon the happening of a certain contingency. So obviously it is a condition precedent of a contract. On happening of something, contract will enforce. If this condition is fulfilled, then the contract will be performed. So to this extent, the condition precedent proviso is found in this. Then after this, further they are saying the writing, the document is left with B. The original document is left with B. A और B में कॉन्ट्रैक्ट हुआ, ओरिजिनल डॉक्यूमेंट ए ने बी को दे दिया. B who sues A upon it. अब B ने A पर सूट किया है ऑन द बेसिस ऑफ दैट डॉक्यूमेंट. B ने A पर सूट किया है ऑन द बेसिस ऑफ दैट डॉक्यूमेंट. A may show the circumstances under which it was delivered. What was delivered? The contract was entered into, the condition precedent was entered into, or the document was delivered. It means what? The document. The document was delivered. अब यहाँ पर कहीं भी ये नहीं कह रहे A seeks to prove the condition precedent. अब क्यों ये सवाल उठेगा? Why they are talking this? I don't know. But यहाँ पर ये कहीं भी नहीं कह रहे हैं कि that A seeks to prove the condition precedent. Had A seeks to prove the condition precedent of the contract in document, if there is an oral agreement regarding the condition precedent, if there is an oral agreement, then obviously proviso number 3 had apply. But here the facts you want to prove is not the terms of the contract. You simply want to prove the transaction in which he has delivered the documents to B. अब इसमें कुछ भी हो सकता है because the illustration is not properly worded. अब हो सकता है कुछ ऐसा हुआ हो कि B ने ओरिजिनल डॉक्यूमेंट्स के बेसिस पर सूट कर दिया and A is claiming that the terms of contract was different and that was not the one the B is alleging. And then the court asks him to produce the document of contract. And then A says that I do not have the document because I delivered to B. So B is in the possession of the original document. And now B denied that कि मेरे पास कोई document नहीं है. And then A has to prove that actually the document has given by A to B. So this fact that I delivered the document to B, A delivered the document to B, this is what he seeks to prove. So that is not the term of the contract. And therefore, this one is also out of the ambit of the section 91. So this is just a speculation I have made about this illustration. Otherwise, जो illustration है इसको देखकर बड़ा अटपटा सा लगता है. That A is giving proof that he has delivered document to B. A evidence क्यों देगा for prove that he delivered documents to B? Why he will give evidences that he delivered to B? जब तक डॉक्यूमेंट्स पे कोई सवाल नहीं उठेगा तब तक एविडेंस की कोई रिक्वायरमेंट नहीं होगी. And therefore I just created a situation that B has filed the suit on the basis of the contract, and there the A alleged that the terms of the contract is different, and B says that the terms are that he is alleging. A says that the documents is with the B and he must produces the document. Then B says that I do not have the documents. Then A must prove that he has given the original documents to B. Now what are the circumstances जिसमें वो उसने दिए? I don't know. तो यहाँ पर आपका 91 तो नहीं लगना. So write down upon this. In this illustration J, the fact sought to be proved is not a term of contract. Rather, it is the transaction of delivery of the original document by A to B, and therefore it will not fall under section 91. Hence 92 and or its proviso will not apply. So it is as simple as that. Why it is required to prove that I have delivered the document? That is not specified in this illustration. क्यों A को प्रूव करने की जरूरत पड़ेगी कि ओरिजिनल डॉक्यूमेंट मैंने B को दे दिया था, वो इलस्ट्रेशन में नहीं लिखा है. But what I have suggested, the situation is maybe like this, that B is claiming something on the basis of contract, B is suing something on the basis of contract, but he is not producing the original document. Maybe एक फोटो कॉपी करा ली उसने कॉन्ट्रैक्ट की, और बीच का जो पेजेस थे उसमें डिफरेंट टर्म्स लगा के चेंजेस कर दिए और उसकी फोटो कॉपी करा ली, तो बीच के जो पेज के टर्म्स चेंज हो गए. अब ए के पास उसकी ना कॉपी है ना ओरिजिनल है. अब ए want to be suggesting that there is something else written in that document, and A is alleging that there is something else. When the court asks A to produce the document, and the court A asks to produce the document into the court, and then A wants to prove in the court that I am not having the document because I given the document to be in certain circumstances. So that's it for this topic and this lecture. Thank you for watching this lecture.